Welcome back. I'm Alfred Lambermont Weber, and today we have an extraordinary guest who is Dr. Richard Cordero, who is a doctor of law, graduated from the University of Cambridge in the UK. He's a lawyer based in New York and a researcher writer on federal law. And I contacted Dr. Cordero and his work on judicial discipline reform because I believe that he is doing outstanding work on bringing to public light the systematic problems that need to be reformed in the U.S. federal judiciary. And I say this as a former adjunct professor of constitutional law at the university level and a former judge at the Kuala Lumpur War Crimes Tribunal and other citizen tribunals of conscience. Welcome, Dr. Cordero.
Thank you very much for having invited me to your program. I'm very pleased to be here.
Oh, good. We're very glad that you're here. Now, I would like to ask you, what first got you interested and started in this important work?
Well, as a practitioner, I encountered so many problems, and I realized that it was not simply a coincidence that I was having all those problems. So I started to look for the conditions that made possible for judges to disregard the law, disregard the facts, forget about the rules. And that's how I began to do research in original publications of the federal judiciary. Those are particularly the statistics that are gathered by the courts and then submitted to the administrative office of the U.S. courts. As the name says, this office only provides administrative services, and it was set up by Congress, so it's an official body of the federal judiciary. In fact, the chief Justice of the Supreme Court is the person who, together with other judges, appoint the director and the assistant director of the office. So this office has to gather the statistics on, for example, the complaints that are submitted by people against judges. Anybody, even a judge, can submit a complaint against a judge, and he has to submit the complaint to the chief judge. He has to submit the complaint to the chief judge of the pertinent circuit. Well, I gather the statistics of those complaints. I tabulated them for more than 12 years, and I found out that on average 99.83% of all complaints filed with the chief judge of the circuit are simply dismissed without any investigation. And that tells you that the system doesn't work. And that system was set up by Congress because the complaints are filed under the Judicial Conduct and Disability Act of 1980. That means 34 years ago.
Yeah, so just, sorry to interrupt you, but just to get that statistic correct, what you found was that 99.82% of complaints are dismissed by judges in U.S. federal courts without any action.
Without any investigation, exactly.
Wow.
And they are not supposed, the chief judge is not supposed to pass judgment on the merits of the complaint. He's simply supposed to review it for formal elements, whether the complaint has been filed with the proper chief judge and whether the judge is subject to the act. But nevertheless, he dismisses of the 13 circuits. There are 13 circuits in the federal judiciary, and those complaints are simply dismissed without any investigation. And then when a person who has had his or her complaint dismissed petitions for review to the Judicial Council, up to 100% of those petitions are denied. Now, the Judicial Council of every circuit is a body of about half of the judges of the circuit, together with district judges and the bankruptcy judge. So this council of the circuit doesn't have any adjudicative function whatsoever. It doesn't decide cases. It provides administration the same way as the administrative office of the U.S. courts provides administrative services for the federal judiciary as a whole. But nevertheless, by law, it received petitions for review of those dismissals. Now, up to 100% of those petitions are denied. Now, this is very important because I was tabulating the statistics for 12 consecutive years. In those 12 consecutive years, in the Second Circuit, you had at least 2 chief judges. It is impossible for all the members of the Judicial Council to agree 100% for 12 years with the decision of 2 different chief judges dismissing those complaints. What that tells you is that there is a systematic denial of the application of the law. As a matter of fact, the judges have abrogated an act of Congress. They have arrogated to themselves the power to abrogate an act of Congress. And they do that in self-interest, because it is in self-interest not to go ahead with any complaint of any one of them. And the reason is very telling. Those judges are life tenured. They can stay in place forever. They do not have to run on elections like state judges that have to raise money and every so many years run for re-election. They are not reappointed. They are appointed once, nominated once by the president, and then confirmed by the Senate of the US, and then they stay there forever. So some of those judges have been in place for 1, 5, 10, 15, 20, or 30 years or more. Like several of the justices of the Supreme Court have been judges for more than 30 years. Now, they know so much of each other that they cannot allow any one of them to be put in a situation where he would be tempted to engage in plea bargain. Like, I give you a bigger fish if you give me leniency. Then I tell you, I give testimony or I give information concerning the wrongdoing of other people, of other judges, or even other members of the judiciary, because of the judiciary has people that are not judges, that they provide administrative services. There are lawyers that provide research for the judges. But any wrongdoing within the judiciary is unconscionable. This is supposed to be the branch of government that provides justice. It administers a justice, and it works under the logo equal justice under law. That is the inscription on the frontispiece of the Supreme Court of the United States. So everybody is supposed to provide justice equally to themselves, to other members of the judiciary, as well as people outside the judiciary, the people that are parties to cases. And nevertheless, what they do is they use their power to protect each other. Now, neither you nor your audience have to believe me. You can simply go to the official website of the U.S. courts, and you will see there the section on the menu bar of statistics, and then you download the annual report of the director of the administrative office of the U.S. courts, and you will see there for so many years the annual report, which is submitted by law to Congress. And then you can see there the statistics, and you can do what I did in my study. Now, my study is the one that I sent you the link to. And
yes, and is that up on your website now? Judicial-discipline-reform.org.
Yes.
Yes, good. We will provide links to all of those, and that will be in the video description to this interview, so that the viewing audience can go in and they'll have access to all of that. Now, I just want to remind the viewers of some of the summary statistics that you have brought forth, namely that not only are 99.82% of the complaints dismissed, but 75% of them are just summary orders without any reasons. And you mentioned up to 11 additional non-publishable and non-precedential orders. What does that mean?
Yeah, okay. Now, well, before I answer that question, I just would like to point out that it would be better for you and the viewing audience to download the study.
Okay.
So you put the link there that also
has
Honest Jude Advocates PDF.
Okay.
Because what I have done is not to put the information on my website.
Okay.
I have had so many problems, and I do not want people to be dependent on the website still being allowed to be on. So what I do is I put all my study on a PDF. It has thousands of internal links. It works as a website that you can download. So when you normally go to a website, you see many links that take you from one page to the other.
Yeah.
I've done that exactly in my file. I have thousands of internal.
Yes, so just before the interruption, you were talking about why you have gone ahead and prepared all of these PDFs, which we're going to have a convenient place where people can download the
PDF.
Yes, yes. And I just want to mention to people that, so that they understand the pioneering work that Dr. Cordero is doing, and not to make too much of it, but it should be part of the record, that just before airtime today, this morning in New York, Dr. Cordero's laptop was mysteriously taken out, and he's using a laptop borrowed from a colleague for this Skype interview. So he is under a great deal of targeting, I believe, in my considered judgment, and he's a very courageous professional to bring this information forward. Now, I just want to mention this by way of context, Dr. Cordero, because you're bringing to light that in the entire history of the United States, only the entire 225 years, is it only 8 judges have been dismissed for cause? Is that it?
Have been impeached only 8 judges, and for comparison, on September the 30th, 2011, there were 2,131 justices, judges, and magistrates in the federal judiciary, which means that since its creation in 1789, 225 years ago, there must have been many more thousands of judges, and nevertheless only 8 have been impeached and removed.
And so what you're really showing through these statistics is that this low number is not because of the impeccable conduct of the judges, but because of a systematic arrangement within the judges to suppress any complaint against their impeachable cause of conduct.
Yes, and it is important to notice that from the beginning there was no system for monitoring judges. It was precisely because some senators in the U.S. Senate realized that there was no mechanism to impose discipline among judges, that they came up with the act that I mentioned before, the Judicial Conduct and Disability Act of 1980. And it was supposed to allow people to complain, because before that there was no organized formal system for complaining against a federal judge. And nevertheless, it hasn't worked. But what is more important is that the fact that it was a Congress that adopted in 1980 this act, and that has received the annual report with the statistics on those complaints for now 34 years, and nevertheless nothing happens, nothing has changed. Now, if Congress receives this annual report with the statistics of complaints and sees that year after year nothing happens, the complaints are dismissed, and it is important to notice that the categories of these complaints are dramatically important. They include bribe, they include conflict of interest, failure to make decisions, so corruption. So the administrative office of the U.S. courts knows that the complaints that are received by the different courts and that are then transmitted to them statistically are very important, are very serious. How is it possible that they are dismissed systematically by the chief judges? Congress knows that because it receives the statistics annually showing that year after year there is no investigation. There is a provision in the law to set up a committee to investigate a complaint, but no committee is set up. And as I mentioned before, when the petitions for review of those dismissals go to the Judicial Council of the respective circuit, they are dismissed, even at the rate of 100%. That means that there is a connivance between Congress and the judges. The senators and the members of the House have allowed judges to abrogate one of their acts, and they do that in self-interest, because they know full well that if they were to be known as the nemesis of the judges, one day they may appear before a federal judge on charges against them, and then the judges would retaliate against them. And this is not a far-fetched possibility, because if you see the statistics and the names of the senators and other members of the House that I have on my study, you will see that even though in Congress there are only 535 members, which means about 1/4 of the judges and magistrates in the federal judiciary, in the last decade, there have been more members of Congress removed for corruption, even imprisoned, than in the whole 225 years there have been members of the judiciary removed from the bench, because it is not the same to remove a judge through impeachment and going to jail. Through impeachment, you simply remove the judge. Nothing happens after that. You would have to file, that means that the prosecutor, that means the district attorney, a person with authority to prosecute charges, would have to file charges against that judge that has been impeached in order for him to either pay a fine or go to jail. So you can do whatever you want, knowing that you are not going to be removed as a matter of fact. But if you were to be one judge that every 30 years is removed from the bench, nothing would happen to you, unless the district attorney would file charges in court in front of your colleagues to bring charges to you, to impose a fine or to send you to jail. And he is not going to do that, because if he does that, the judges before whom he would have to bring charges would close ranks, and that district attorney, and in fact the Department of Justice, would not win a case again because of retaliation. So it would be simply a matter that the judge would lose his office, but nothing would happen after that. It is not even certain that that person would not receive his pension. There was a judge in the South that was impeached and removed, and the Congress still had to pass a personal law. It's called a restricted act to remove that person from the federal salaries, so that that person would not continue receiving his salary or his pension. This is simply beyond belief, that you can do everything. If you are caught, you lose your job and nothing happens. So there is a connivance between the judges and the members of Congress, and there is also between the judiciary and the president. And there is a precedent for that. When Roosevelt began with his New Deal laws in the late 1920s and particularly the early part of the 30s, his laws were declared unconstitutional when they arrived in the Supreme Court, one after the other. So Roosevelt tried to pack the court, to put more members on the Supreme Court, but that was deemed to be an interference with the judiciary, and that proposal did not go through. But everybody, even the presidents, realized the immense power that judges of the federal judiciary have to doom to failure the legislative agenda of a president by simply declaring it unconstitutional. And President Obama came within a whisper of having that done to his Obamacare Act, which is his signature legislation. If the Chief Justice, who is a conservative, had voted with the other 4 conservative on a court that counts up 9 justices, Obamacare would have been declared unconstitutional. The Chief Justice switched side and voted with the other 4 liberals, and that is why Obamacare, instead of having gone down in history as in a footnote, it is now the law of the land. But that tells you that the president was very much aware that he ran the risk of having his signature legislation declared unconstitutional, and then he would be a failure of a president. That's why the Department of Justice, that obviously is a part of the executive, doesn't prosecute judges, doesn't investigate them, because it would simply provoke a retaliation on the part of the judges. And that means that there is this class of people above the law. As a matter of fact, they are above the law. When you can have a job security beyond any question for life, earning a salary that is on average 4 times the average salary of Americans, then you know also that the journalists are not going to take you on because they would be exposed to retaliation. There is nothing that can be done to you as a federal judge, neither in the press nor in by the authorities, by the Department of Justice, by Congress that can conduct its own investigation. You can do whatever you want. You are above the law.
Now, yeah. Let me ask you two things, and then I'd like to go on to the topic of the concrete ways in which their wrongdoings of the judges harm people. But I'd like to quickly just, one is the secrecy of the meetings in these attempts to complain against judges. And secondly, you brought up a figure of $373 billion in 2011. Could you talk about those two things briefly?
Yes. Can I answer the question, because it is very related to this?
Sure.
The decisions. You mentioned before 75% of appeals. It has nothing to do with complaints.
Okay.
These are regular appeals.
Oh, regular appeals. Oh, I see.
Regular appeals of cases that are submitted to the circuit courts. So in the federal judiciary, you have 4 levels. You have the bankruptcy courts, right, the district courts, the circuit courts, and then the Supreme Court.
Oh, right.
Okay. So when they go from the bankruptcy court to the district court to the circuit courts dismiss up to 75% of all appeals by just a piece of paper that
denied.
No, on the contrary, affirm. Because
affirm. Sorry, right. That's what I mean.
Affirm the decision of the district court below, because it would be so much more difficult to read all the briefs, check the law, and then write a decision stating what was the reversible error that the district court below committed, so that on remand he doesn't commit the same mistake. That would defeat the purpose of the summary order, which is simply a mechanism to dispose of appeals summarily with nothing done. And when I say nothing done, is that you have only one operative word that says affirm. That's it. Summary order, that means that there is no discussion, there is no reason. But not only that, as you mentioned before, up to 11% of additional decisions are reasonless. They simply have a statement that is so poor that the very same judge that wrote it writes not for publication and not precedential. Not precedential means that you, as a party, cannot cite to that decision as precedent of what the judges did before. And now, what does that mean? That a judge that writes an opinion so poor that he doesn't want other people even to have access to it, he writes not unpublishable. But if they were to get to that decision, because they go to the courthouse and get it there, it would be useless because it has no precedential value. So that means that a judge that writes an opinion like that can write it arbitrarily. It doesn't matter. It doesn't count. It is as if nothing had happened because nobody else can use it, even though our system, like yours, is based on precedent. You establish a pattern of law by harking back to what other judges have decided in other cases that are similar, or you establish that there is a difference and the precedent should not be applied. But nevertheless, there are some rules, there are some parameters that you can invoke by referring to decisions that have been made before. In this case, there's nothing like that. 75% of the decisions by summary order doesn't have anything that you can refer to. It simply says affirm in most cases. And in the other cases, by the decision of the judge himself, it is not precedential. It has no value in any other case. Now, what you mentioned about $373 billion, it is that in the bankruptcy courts, which are the courts at the lowest level of the federal judiciary, 80% of all cases enter through the bankruptcy courts. That means that bankruptcy cases constitute 80% of all annual cases newly filed in the federal judiciary. 95% of those cases that now average 1.3 million new bankruptcy cases filed in the bankruptcy courts of the federal judiciary. 95% of those newly filed bankruptcies are filed by process, by people, persons. The immense majority are filed by persons without representation of a lawyer, for the very simple reason that if you go bankrupt, then you do not have money to pay $100, $200, $300, $400, even $500 per hour to a lawyer. So you have to fend for yourself. And you do that by filing a bankruptcy petition, which means that you have to fill out the forms. The forms themselves are so difficult that even the administrative office of the U.S. courts have put out a warning to bankrupts that they should try to seek legal advice, because there are so many of those forms that are returned because they are poorly filled out. Now, when you realize that the form themselves is so difficult, you can forget about understanding the bankruptcy code, because this is beyond belief, particularly for a person who has no training in the law. When you read those provisions that send you to another provision, with the exception of this, taking into account of this other thing, it is very difficult for a person that has not received any training in the law to think in that way. So forget about invoking the bankruptcy code or the regulations. You simply do your best by trying to fill out the form, and you submit it to a trustee. The trustee is supposed to represent not you, the bankrupt. You are the debtor. It is supposed to represent the creditors. But the trustee is the one who has the power to recommend the plan of debt repayment that you as a debtor propose to the judge. The trustee is the intermediary representing the creditors, but he's not a completely uninterested party, because by law he receives 10% of every payment that you as a debtor make through the trustee to the creditors. So you are the debtor. If I am the trustee, you pay me. By law, I can keep 10% and then distribute equally the 90% left to the creditors. But before that happens, you submit the plan to me. I check it, and then I ask the judge to either approve it or disapprove it. Now, what happens? Obviously, if I, as a trustee, disapprove of your debt repayment plan, I don't get my 10%, because you are not going to make any payments, because I recommended to the judge that he denies that debt repayment plan. So it is in my interest as a trustee simply to accept anything that comes my way, because then I know that I can get my 10%. Obviously, if the judge approves it. Now, the judge is going to say, hey, trustee, you know what? I have the power to declare that you should be removed from this one particular bankruptcy. But what is the consequence of that? If the judge removes a trustee from one single bankruptcy case, he is removed from all cases. He loses his livelihood as a bankruptcy trustee. And then he's back in queue at the indigent defenders courthouse asking for an appointment. So he has no interest whatsoever to get on the wrong side of the judge. Now, the judge then has an interest in telling the trustee, listen, you come here every day with these recommendations that I accept the debt repayment plans of those bankrupts. And I have to do all this immense work of signing them. That's my work, and that is a lot of work. And you know why it is a lot of work? Because if I don't sign it, if I don't approve it, you don't get anything. And all effort that you may have made in reading those things or simply putting them together and bringing them to me would be for naught. So from now on, I want you to express your appreciation of my signature. That's the way that instead of me telling you, okay, from now on, you were supposed to pay $1,000 to your creditors, I was supposed, by law, completely legal, to keep 10%, that means $100. And then I was supposed to pay $900 to the creditors. But I think that we can do better than that. I'm going to say that instead of you having to pay, let's say, 30 cents on the dollar to your creditors, you're going to pay only 15 cents to the creditors on the dollar. And now of that $1,000, you are going to give me $500, and you are going to keep the other $500, and this is a win-win situation. Except that when the judge knows that, he tells the trustee, this is not a good deal for me because I'm not getting anything and I am doing all the work of signing the paper. So what I want you to tell the bankrupt is that from now on we are going to get $750, I'm going to get $500, and you are going to get $250, and the bankrupt is going to save $250. And if he doesn't like that, you can always tell him that instead of paying 15 cents on the dollar, he's going to pay 35 cents on the dollar. Now, you may think that
but wait. So what you're saying here is that the judges are taking money under the table?
Well, that the system allows them to do that. The system has the incentive to do that, and then there are signs that the system is corrupt, because of when you read the law says that the trustee who represents the creditors has to personally perform a series of acts concerning each bankruptcy case personally.
Yeah.
This is a removable cause for the trustee not to perform those actions personally, and I have seen them all in my brief with reference to the bankruptcy code of provision or the rules that require the bankruptcy trustee to perform personally those actions.
Yeah.
When you find that a trustee can have 3,900 bankruptcy in his name, or 3,300 bankruptcy to his name, there is no way in this world or the next to come that he can take a personal care of those decisions. The only way he can do that is if he's running a bankruptcy mill, where whenever a bankruptcy comes his way, he doesn't even look at it.
Yeah.
He just signs the petition for the judge to approve the bankruptcy, and that's it. And then he keeps the 10%, but what is more? He can engage in those corrupt arrangements with the bankrupt and with the judge.
I see.
And there is evidence of that, because before the current system, it was the bankruptcy judge that would appoint a trustee.
I see.
For example, here in many states, it is the judge who appoints a guardian for a person that cannot take care of himself, and that has led to so much corruption. Why? Because when you have the power of appointment that allows an appointee to earn money, you always have the incentive to sell that power, to say, yes, I can appoint you time and again if you and I come to an arrangement and I get my part and you get your part and everybody is except the other person.
And there's no enforcement against the judges for the reasons that you have cited earlier.
Exactly.
That the judges are in self-protection.
Exactly.
So we have a corrupt federal judiciary, is what you're saying.
Yeah, but in addition to that, you have to understand one thing, that bankruptcy judges are not nominated by the President of the U.S. and confirmed by the Senate. No.
I see.
They are appointed by the circuit judges.
I see.
Judges appoint the bankruptcy judge. Now, you have to realize that if the bankruptcy judge is challenged, when his challenge decision comes to the circuit judges who appointed him, do you think that the circuit judges are going to be impartial when it is the decision of their appointee that is at stake? The normal human reaction is to say, I appointed him because I thought that he was a clever person and a competent one. So from the outset, I am already a partial judge. I have an interest in finding the decision of my appointee to be valid, because otherwise I would indict my own good judgment in having that person appointed as the bankruptcy judge. So the system is created in a way that it promotes corruption, particularly when you know that it is also the circuit judges, together with the district judges, that can remove the bankruptcy judge. It is not the procedure of going to the House of Representatives to impeach the judge and then approve the articles of impeachment and pass it on to the Senate, a very complicated system. No, it is simply the circuit judges and the district judges that can remove the bankruptcy judge. That means that the bankruptcy judge has no interest whatsoever in challenging whatever decision, whatever insinuation the circuit judges and the district judges may make to him. The bankruptcy judge has the power to remove the trustee by simply saying, I remove you from this one single case, and your 3,900 other cases, forget about them because you are automatically removed. So he has an enormous amount of power in deciding not just whether the trustee remains in place, but also in disposing of that $373 billion at stake in only the personal bankruptcies. That means that the 5% of bankruptcies annually filed by companies are not taken into account in that 373 billion. That is simply persons that file pro se in the majority of cases because they cannot afford a lawyer. So when the judge says, no, provision of the bankruptcy code 3525 applies here, the bankrupt who filed pro se have no clue what the judge is saying. He can allocate the money at stake to repay the creditors however he wants. What is more, before that, there are other members of the legal and bankruptcy system that also get their take. The accountants, the auctioneers, the warehousers, the lawyers, they all have a system of working together with the trustee, because the trustee is the one that can say, well, I need a lawyer. The trustee doesn't have to be a lawyer. He simply has to be appointed by the office of the U.S. trustee. It is a federal office, but he's not paid by the office of the U.S. trustee. He's paid by his 10%. So if he doesn't get the bankruptcy petitions approved by the judge, he doesn't get any money at all, because he is not a salaried federal officer. He is an independent contractor, in the sense that he is appointed to be the trustee representing the creditors, but he is only representing himself, because the only way he can get money is by approving every petition for bankruptcy that comes his way, because it has to be submitted to him, and then recommending the approval of it to the judge. And it is important to dwell on this, because $373 billion is more than $1/3 trillion. It is an immense amount of money. If you just take one single piece like this, you get an enormous amount of money that you can distribute between the people that make the system. In fact, the system was so corrupt before 1984 or so, when the new system that set up the U.S. trustee was in place, that the whole bankruptcy system had to be remade, because the judges who were at that time appointing bankruptcy trustees had a system that the investigation of Congress called cronyism.
Well, I mean, the 10% of 373 billion is 37.3 billion. That's the stake that goes to the trustees, which are the cronies. That's a lot of money.
Yeah, that is a lot of money, and with that you can do a lot of things. And what is important is to see how the system works. So when you know that the district attorney to whom the decisions of the bankruptcy court would go has the power, together with the circuit judges who appointed the bankruptcy court, to remove him, then you know that you have a harmonious interest between the district judges and the circuit judges to control the bankruptcy judge. They can remove the bankruptcy judge together. You don't have to impeach the bankruptcy judge. You don't have to ask for an impartial third party like the House of Representatives or the Senate or even any other judge. It is the district judges and the circuit judges that appointed him that can say, we are removing you. And that gives them an immense amount of power to tell the bankruptcy judge, we want also our take.
Right.
So you have to put together these provisions to see how they induce to corruption. But this is not corruption only at the level of the bankrupts that file pro se. I cite the study of Professor Lopuki, who studied bankruptcies where the stakes were higher than $100 million. Some of them were like airlines where the stakes are billions of dollars that are owed by the bankrupt airline to the creditors, and the same corruption goes in. And he writes that book and states how the bankruptcy judge has such an immense amount of power, and there is so much money at stake that it corrupts on the system. And the circuit judges do not intervene. And you say, why? Why would they not intervene? Because they appointed the bankruptcy judge. Whether it is to take care of a person that files because he cannot pay his mortgage and his car, or it is a oil company that goes bankrupt, it is the same judge that wields an immense amount of power. And when there is a very big company that goes bankrupt, there is money for everybody. There is money for the lawyers, top lawyers that charge $500, $600 an hour. There is money for the accountants, for the warehousers, for the auctioneers. The auctioneers are supposed to make an announcement, a public announcement of what is going to be auctioned. That means the assets of the bankrupt that have to be sold so that the money can then be distributed equally to the creditors. So you're not going to give a chair to one creditor and a table to another and the TV. You have to settle that, and then you distribute the proceeds. And the sale of the table, the chair, and the TV is made by the auctioneer. But the auctioneer has to do that by announcing it publicly. In most cases, that doesn't happen, or it is a faked announcement, so that you find that only one person goes on to the auction, because that's the only person that was informed of the auction. And they have every interest of bidding the least amount of money and then flipping the asset and selling it on the open market. So if you have a house that has to be sold, or a piece of other real estate that has to be sold, you're going to bid the least amount of money because you already arranged with the auctioneer, who is also the partner of the trustee, because it is the trustee who finds the auctioneer. And then you flip the property on the open market and you distribute your money, because the worst thing that can happen is to be too greedy. So everybody makes its money,
Right.
and you do not have to find evidence of that in order to see how the system works. The system is inherently corruptive. It corrupts our people because it allows our people to do all that without any discipline, any supervision, any investigation. Imagine this: if you were to file a suit against the lawyer of the trustee, or the auctioneer, or the warehouser, or the accountant, to whom do you have to file that? You have to file it with the judges. You have to file with the district judge. The district judge is the one who has the power, together with the circuit judges that appointed the bankruptcy court, to remove the bankruptcy judge. He's not going to find that the accountant made something wrong, or the auctioneers, or the warehouser, because the whole system can collapse. And because the Congress is not going to investigate any of the judges, and the president has no interest in sending the Department of Justice or the FBI to investigate a matter where a bankruptcy judge is at stake, the appointee of the very powerful circuit judges, the whole system runs on its own without any supervision. And what is important is the amount of money, $373 billion only in the personal accounts. And as I said, the other 5% of bankruptcies filed by companies are not counted there. So if you were to put together all the money that is at stake in the bankruptcy courts, it is an immense amount of money with no supervision whatsoever. Because for you to try to get some supervision, you would have to file a lawsuit before the friends of that bankruptcy judge. And that is what makes the whole system so corruptive. It is made up of judges that are unaccountable. Now this provides now a link to what to do about it. What are the concrete measures that we can take? Well, there is one precedent that is very important. In 1969, Life magazine published a series of articles indicating the inappropriateness of the conduct of Justice Abe Fortas of the Supreme Court of the United States. He had not done anything wrong in terms of the law. He had not broken any law, not even a misdemeanor law. It was simply inappropriate for him to take $10,000 for teaching a summer course at American University. And at that time, that principle of avoid even the appearance of impropriety was not even written, because the code of conduct was written after him in 1974. This happened in 1969. Nevertheless, it was seen so inappropriate for him to do that, that first he had to withdraw his nomination for the Chief Justiceship. President Johnson had nominated him to become the Chief Justice. He had to withdraw his name. But then Life magazine published other articles establishing the link with a shady person, and that provoked other media and people in government to protest so loudly against Justice Fortas that he had to resign. There was no law broken. There was no lawsuit filed against him. There was no investigation by the Department of Justice. There was no investigation by Congress, no hearings on that. It was simply the appearance of impropriety. That is the principle that applies to federal judges, and in fact it has been adopted by many state judiciaries. Avoid even the appearance of impropriety. Now, what I am trying to do in order to expose the system is to center on two cases that are unique, that involve people at the top, that can cause such an appearance of impropriety that it would cause a Chief Justice or a Justice of the Supreme Court or even the President of the United States to resign. There is precedent for a President of the United States to resign. Nixon had to resign on August of 1974 because he had been found to have committed improprieties in the Watergate case. He wasn't taken to court. He was not impeached. The articles of impeachment were being prepared, but he resigned before that. So there is a precedent for a president of the United States to resign without him being charged formally in court or through the impeachment process. Now, the case that is a concrete, the unique national case, has its basis on a series of articles published by the New York Times, the Washington Post, and Politico, three top American newspapers, suspecting then Judge Sotomayor of concealment of assets. What they asked was, where is the money? Because of her salary as a district judge and then as a circuit judge of the Second Circuit was a matter of public record. And they asked her, well, if she has earned so much money through all these years, how is it possible that she only declares these assets? Where is the money? Particularly when they ascertained that she did not spend money in luxurious vacations or on fancy cars or at restaurants, expensive restaurants. She was said to lead a frugal life. She didn't have a husband. She didn't have kids. She didn't have any dependents. Where is her money? So on that basis, and then on the basis of the papers, her financial statements that she had to submit to the Senate Committee on Judicial Nominations when President Obama nominated her to the Supreme Court, I put together a table. It is referred to in my study, and tallied all the assets and the liabilities that she herself submitted under oath to the Senate Committee on Judicial Nominations, and I found that there were about $3 million unaccounted for. Because once you earned money, you do something with it. The money just doesn't disappear. You spend it somehow. And if you spend it in productive enterprises, then you have to pay taxes on that investment, on that productive enterprise. But if you don't declare it, you don't pay anything. You pay only once. You pay when the money is paid to you as a salary, because that is a matter of public record. But what you do afterwards with the enormous amount of money that a federal judge earns, as I said before, about 4 times the average earning of Americans, you can make a lot of money. And it is nowhere. So I found that there was this appearance of impropriety there. And I asked myself, as anybody would ask, if those papers, the New York Times, the Washington Post, the one who was instrumental in bringing down President Nixon during the Watergate affair, it was the Washington Post that investigated him the most, the first, and Politico, that is a very respected newspaper. They all published those on suspicion of concealment of assets by Judge Sotomayor at that time. How is it that the president didn't know anything about it? Particularly when, by law, the FBI, which is an agency of the Department of Justice, has to vet every candidate to become a federal judge. And it has every interest in doing the best job. in vetting that candidate, searching his or her background, trying to find anything that can be used against her confirmation by the Senate. So it is not the FBI that has any interest in doing a bad job, because if it does a very good job and it finds that the candidate is inappropriate, that it is going to have a very hard time being confirmed by the Senate when this particular piece of information adverse to him comes to light. The FBI would say, since the report, the vetting report, is secret, it goes only to the president. The FBI has no interest whatsoever in falsifying the information, because it wants to be said later on the FBI is guilty of having this nomination by the president doomed. No, because nobody would know that. The report is secret. But there is the suspicion of impropriety already in the public, made by these three well-known publishers. Why would the president go ahead with that? First of all, because once the judge is confirmed, hardly anybody is going to do anything else against that judge because of the fear of retaliation. But the president also had another interest. It was Obamacare. Why? Because the people that were petitioning for the replacement of retiring Justice Sotomayor to be another woman or the first Hispanic could provide excellent support when Obamacare would come to a vote in Congress. And Justice Sotomayor satisfied both requirements of being a woman and being Hispanic. So the president nominated her, knowing that with her nomination he would ingratiate himself with those groups that were asking for another woman and the first Hispanic to be nominated to the Supreme Court. And then obviously at the time that the piece of legislation would be challenged, because everybody knew that given all the opposition to Obamacare at the time it was going through the congressional process, that it would be challenged eventually, and it would go to the Supreme Court. The Supreme Court would have to decide. And obviously a nominee of the president would most likely be in favor of that piece of legislation. So it was in the interest of the president to ingratiate himself with all those petitioners for another woman and the first Hispanic, and also to have his own nominee to thank him for his nomination. Now, as I said before, the standard in the federal judiciary is not that you have to provide conclusive evidence as if you had gone through the process of filing a case, going through discovery, going to trial in an adversarial system, and then having a jury find your way. No, the only thing that you have to do is to raise the appearance of impropriety. If the journalists together at the same time started to investigate this relationship between the president and Judge Sotomayor, and started to look into the whereabouts of the concealed assets that the New York Times, the Washington Post, and Politico suspected her of concealing. that would create the appearance of impropriety. Moreover, you can always have this group of journalists demand that the president release the FBI vetting reports that are secret. You can ask Justice Sotomayor now to ask the president to release them. And you would put both of them in a very difficult situation, because if they were to refuse to release those reports, they would be suspected of having something to conceal. And if they release them, then they would simply confirm what these other three papers had already suspected, that she was concealing assets. And you would not have to find the whereabouts of that money and say, okay, in this offshore account or in this building, we have the investment of her money. No, it would be sufficient to create enough appearance of impropriety to cause her to resign. But what is more important than that is that in that investigation, you would find people asking the question, what is the circumstances enabling such wrongdoing? Why? Because by law, every federal judge has to submit an annual financial disclosure report. I have downloaded some of them. I have reviewed those that Judge Sotomayor at the time published. They don't make any sense. Sometimes you find that a judge, year after year, files those reports with the same figures. Who on earth has the same financial situation year after year? Particularly when you get to a certain age where you don't have commitments of children and you have more disposable money, you can invest the money and the investment can go up and down. How is it possible that year after year you file those reports with the same figures? It doesn't make any sense until you understand that judges file those reports with their peers, with a committee of judges who themselves have to file those reports. So they have absolutely no interest in challenging those reports, because they would be then setting standards that would be applied to themselves, or that they themselves would have to apply to their own financial reports. And everybody would know that because those reports are public. So if the judges that receive those reports were to be too strict, people would say, why weren't you strict with your own reports? Copy of which we have here, because you had a legal obligation to file them publicly. This is the same principle that I discussed before. You put together the circumstances that enable wrongdoing, that provide the incentive, and that allow the people to be corrupt. And because you already know that you have the most insidious corruptor, money, around, then you have to find the way of investigating whether that money that was available actually corrupted the people, because of the circumstances allowed them to do so. And here, if you had a group of journalists investigating Judge Sotomayor at the time, Justice Sotomayor now, you would have them investigating the circumstances that allowed her year after year to file those financial disclosure reports that are meaningless, that give rise to suspicion of concealment of assets. And you would then extend, naturally, journalists would ask themselves, how many other judges are doing the same? So that means that the investigation of Justice Sotomayor would be a Trojan horse into the federal judiciary. There would be so much appearance of impropriety when all these details came out. And most of people do not know them because most people don't have the faintest idea of what the administrative office of the U.S. court is, what the judicial councils are, what they do, what the annual report of the director of the office is all about. So they have not done the necessary research to find what are the enabling circumstances of wrongdoing in the federal judiciary. And in journalistic terms, those are called leads. I have a lead. There is something suspicious here. There is something that allows people to behave in a corrupt way, so I am going to pursue that lead. And the point is that if you had a group of journalists investigating Justice Sotomayor at the same time, the judges would not be able to retaliate against all of them simultaneously, simply because they would then reveal their wrongful motive, retaliation. Retaliation is wrongful because it is unconstitutional. It goes against the First Amendment that provides freedom of the press, freedom of speech, and the right to assemble peacefully to petition the government for a redress of grievances. So retaliation is unconstitutional, it is criminal, and it could expose the judges that engaged in it. But that would only happen if there is a group of journalists pursuing the matter at the same time. And now you would ask, well, before we discuss the interest of the circuit judges, how it was harmonious with the interest of the bankruptcy judge and the district judge, and we would have to ask, what would be the interest of the journalists in pursuing the case? Well, the interest is to be this generation's Bud Woodward and Carl Bernstein of the Washington Post, the very first two reporters that investigated the Watergate case. At the time, in 1972, June 1972, they began to investigate this group of 5 people that were caught in the Democratic National Headquarters in the building complex called Watergate in Washington, D.C. And at that time, they were derided by the press as the 5 plumbers because they had tools and they were dismissed as just engaged in what was called at that time a garden variety of burglary. So Carl Bernstein and Bob Woodward pursue this matter, and they find out that the people representing these 5 burglars in court were top Washington, D.C. lawyers, and they ask how is it possible that they can afford this. And that's how this follow the money investigation began by them, that landed them in a bank in Miami that had a connection to a slush fund of the Republican Party. And that's how they came upon the discovery that there was a slush fund in the Republican Committee for the re-election of Nixon that paid for the burglars to go into the Democratic National Committee headquarters to commit political espionage. That means that there is the means of starting, even with the two reporters, an investigation, and then extending it naturally to other journalists through competition. Competitive forces were driving every other journalist and every other media outlet to investigate Watergate because they could not afford not to publish news on the matter, since everybody was so interested. That is precedent for what I am proposing now. What I am saying is that to begin with, instead of just finding two courageous journalists that would investigate this matter further, to put together a press conference or even a private meeting of journalists, and then we can make a presentation to them of the abundant amount of evidence already available in the leads that are in the articles of the Washington Post, the New York Times, and Politico, in the leads of the financial statements that then Judge Sotomayor herself submitted to the Senate, in all the laws that I have discussed now that provide the background for people to behave in that way, and then they can follow it. And then they can also use or try to appeal to the expertise in follow the money investigations that has been gained by the International Consortium of Investigative Journalists with headquarters in Washington, D.C. About 2.5 years ago, they received in the mail anonymously a hard disk with more than 250 gigabytes of financial information. And they investigated more than 1.2 million documents, found that there were more than 100,000 offshore entities, not accounts, offshore entities. And they tabulated the amount of money that might be concealed, might have been concealed through these offshore accounts, and came up with a figure of around $24 trillion. And that was the reason why the G8, the 8 more industrialized countries and Russia at the time, agreed to new rules for the exchange of financial information, because through this report that the International Consortium of Investigative Journalists, I have the letter, the address, everything is in the file. You just search the terms that I have given you in the PDF box, and everything is there. The file now has more than 515 pages, and everything that I have said here is there. You only have to read the first initial pages, the 3 pages, and they have so many references. Okay, so with these journalists, we can appeal to the expertise of this consortium for follow the money expertise, which means that the journalists that do not know the intricacies of this type of investigation do not have to rely on themselves and invent things on their own. They can appeal to the consortium for expertise. But what is even more important is that the standard is not that you find the concealed assets. That is not the standard. The standard is that judges must avoid even the appearance of impropriety. So it would be enough for the journalists to create this appearance of impropriety, linking it to the president, because the president knew all of it at the time. And as I said before, he would be under an enormous amount of pressure to release the FBI reports. So would be Judge Sotomayor. Now, the other story is also related to this. As I said, the investigation of Justice Sotomayor would be simply a Trojan horse. It would be enough to cause her to resign, let alone to be impeached. But what is more important is that the journalists, through her investigation, would ask themselves how it was possible for the system to allow her to do that, and then they would investigate the coordination of wrongdoing that goes on in the federal judiciary. And the second story shows that type of coordination. The second story deals with the federal judiciary and the National Security Agency, the NSA. The NSA, by law, has to request the approval of secret surveillance orders through secret requests to the secret court established under the Foreign Intelligence Surveillance Act. It is called FISA. Those are federal judges, and they have to approve every secret request. Are we still? Yeah. Okay. I thought that we had lost our connection.
No,
they have to approve of every secret order. Now, the Washington Post published a graph of all the requests that had been made to this secret court composed of federal judges. And it found that in 2012, 100% of those requests were approved. That's why the term rubber stamping approvals came about. Now, when you know that you are going to approve the request of the NSA, are you going to waste your time reading it? Of course not. Why would you write an opinion, which is secret? It cannot be challenged, because obviously if the request is secret, the person that is going to be surveilled doesn't know about it, has no means of challenging it. So the NSA made this request to the federal judges of the secret court set up by FISA. They approved it. Now, the NSA, as you know, has an enormous expertise and network of computers. The question is, to what extent there has been a quid pro quo between the NSA and the federal judiciary. I submitted my requests for approval to the federal judges, and in turn, the federal judges request that we use our expertise to transfer money to offshore accounts or to hidden accounts from declared accounts. That means the money is paid to the judges through declared transactions, because the salary is a matter of public record. So there is no any hidden aspect in the intake of money by the federal judges. But what they do after that, how they use the immense power that they have to know in advance of deals that are in the making, because they are submitted as part of cases that come before them, to use that knowledge to make investments that nobody is going to investigate. When you have a lot of money and you know that nobody's going to investigate you, why would you not use that power to make more money, knowing that you will not have to pay taxes and that nobody is going to dare expose you because of the retaliatory threat that you pose? You have to understand also that all these people, all these judges were recommended, supported, endorsed, then nominated and confirmed by politicians, the very same people that now are at the bottom of the public esteem because they are deemed to be in Congress in self-interest. They are not representing the interest of the people, they represent their own interest. And the amount of insider dealing that goes on in Congress has been exposed and criticized by, among others, the Washington Post. That means that the people that appointed the federal judges are corrupt themselves. Why would they ever appoint people that would be so straight, so concerned with compliance with the law, that would make problem for the appointers, for the nominators, for the endorsers, for the recommenders of the judges? That means birds of the same feather fly together. The judges that are appointed or endorsed by politicians that are corrupt are no better than they, because they form a class that have harmonious interests. So when you analyze all these problems using this principle, dynamic analysis of harmonious and conflicting interests. This may sound esoteric. It's simply what you do at home. You find among your siblings who has an interest in going to the beach instead of going to a party next weekend, and you make an alliance with that person. And if you find that your mother has an objection to that, well, you have to find a way of conflicting her out. Perhaps you say, hey, Mom, I saw what you did this time. I tell Pop, if you don't go along with me in trying to go to the beach this weekend, or allowing me to go. That is what is involved in this principle of dynamic analysis of harmonious and conflicting interests. You try to find out who has an interest harmonious with yours and who has an interest in conflict with yours, and then you figure out, using your common sense, the common sense that jurors are allowed and encouraged to use, to analyze the situation. And if you see that the circuit judges, for example, are the ones who appoint the bankruptcy judges, then you know that they have a harmonious interest, because there can be no interest on the part of the circuit judges in indicting their own appointees. And that is the way the system, the analysis goes. And it is dynamic because of whenever one party comes in with a interest either conflicting or harmonious, then you have to analyze the rest of the people in the system to find out how they now are going to relate to this new interest. And that is what the journalists would do. They use this principle. They use the leads in the articles of the Washington Post, the New York Times, and Politico, in the financial statements filed under oath by Judge Sotomayor with the Senate, and then they figure out what are the people that would have an interest in helping the judges to transfer money to hidden account, to make hidden investments, knowing that they would be protected. If you read the report of the International Consortium of Investigative Journalists, you would realize how many people at the very top had an interest in helping the wealthy, and the very wealthy hide the money that they had. And then, if you're a person that are up to date in what is happening around you, you know that a bank of Paris, of France, was engaged in violating the laws of the US to conceal assets and avoid the payment of taxes by wealthy American depositors. Another bank in Switzerland was engaged in circumventing the the prohibition against trading with Cuba, with Iran, and with other countries. So you know that even financial institutions at the top of the pile of banks, in the US there are thousands of banks, even those banks at the top engage as a systematic way of doing business in doing wrongdoing. Why would they not do the same thing for the judges, knowing that nobody's going to investigate the judges? Forget about it. It hasn't happened in 225 years. There is no interest now in it happening because of the retaliatory power that they have. And I have listed some of those retaliatory powers. It is not that they necessarily have to ask some thug to beat you up. No, they can simply change, ask a court employee that works at sufferance. That means that can be dismissed without any reason. They can ask him, change the name on that file, change the date, lose that file, backdate it, put the date forward. And the person that filed that paper would be found to have missed a deadline, or would have found that actually he did not miss a deadline. However, the judges want the case to be. Why?
Yeah. And I can attest to that because I was pursuing in the late 1980s a series of complex cases in the courts of Canada and the US in which my entire case file, just enormous series of documents, the Circuit Court of Appeals for the 11th Circuit in Atlanta, Georgia, wrote back that they had, quote, lost the entire record. Which was voluminous. They lost it.
Yeah.
They lost it. And that was it. So I can attest to that. Now we have gone now for quite a while, but I think this is such an important program, Dr. Cordero, that I was wondering, you have listed 13 different ways, and most of our viewing audience, if not, practically all of them are not practicing attorneys, and but I'm sure that they may have been involved in lawsuits. They know how every time that they've heard stories about when you go to try and get your rights in a court of law, you're likely not to get them. But you have listed the 13 ways, at least, concrete ways in which wrongdoing judges can harm people. I was wondering, taking not more than 30 seconds or a minute to each, perhaps just reading them out because we are short of time, could you just list those so that people will know them and will hear them?
Yeah, I think that even more important than those on specific cases in which judges can retaliate against people is the fact that judges in the federal judiciary make a decision about abortion, about marriage, gay marriage, or about the use of weapons, the inspection of property in order to exercise eminent domain, that means expropriate you and then buy your property for public use. The federal judges make decisions every day that affect our property, our liberty, the way we live, our rights. So you do not have to have a case in court. You do not have to read those 13 ways in which judges retaliate in order to realize that the judges in this country and in most countries have actually the most amount of power, because a law that is passed in Congress and enacted into law by the signature of the president is only black ink on paper until the judge says, yes, it is constitutional. Now we have a law. Before we have only blotches of ink on paper. And then it says, the judge says, and it is to be understood in this way. Now he interprets it and he applies it. And he affects the way you live, the way you marry, the way you die, whether you have the right to euthanasia or you don't, what amounts to be a person in the foreclosure business and fraudulently taking your house. All those rights that affect the value of your property are determined by judges. They have the power to interpret the law that affects you. And that is why even people that do not know those 13 ways, and there are more, of judges retaliating, they should be concerned too. Because in a system where we have the principle of the rule of law as the guiding principle of our government, that means that it is not a government of men, it is a government of law. And what applies is the rule of law to determine the relationship between government and the people. In that system where the judges apply the law, it is very important to have people that are honest. And if they are not honest, then it doesn't matter that you do not have a case in court, because you are going to be affected all the same. And what I would like to bring to the attention of your audience is that they should try to download the file, read as much as they can, because everything that I have said in here is referred to in more than 300 footnotes, each of which has 1 or 2 or 3 or 4 or 5 or 6 or 7 parts. So if you were to multiply the footnotes there, you would come to well over 1,000 footnotes. All the evidence is there. You do not have to believe me. You have to believe yourself. The research is already done. It is only a matter of clicking on the links or reading more in another part of the file, and then you come to this idea: how is it possible that in a system that is supposed to be based on the rule of law, we have entrusted the basic functioning of our government to people that are above the law, of people that have the right to be dishonest? Now, applying the principle of the circumstances enabling wrongdoing, when you have people that for their own interest can engage in wrongdoing, can disregard the law, can disregard the facts, and make decisions in a predetermined way because they don't like it. They couldn't care less for that case. They dismiss it with a summary order. They dismiss it with a decision that has no reasons, that has no precedential value, that has it's not publishable. Do you think then that those people have the disposition to be honest in your case, to be impartial in your case, to be fair? No, the human mind doesn't work in that schizophrenic way that I'm going to be dishonest only when it benefits me, but I'm going to be very honest when it affects another person. That is not the way a person functions. That is why the principle in the federal judiciary is avoid even the appearance of impropriety. And that goes even to personal matters. So if you read the code of conduct of U.S. courts, the personal life of a federal judge determines whether he has engaged in that impropriety, the appearance of which should be enough to provide grounds for resignation or impeachment. And that is more important than reading the 13 ways in which, because that tells you that everybody's concerned. That in a system where the rule of law should be the guiding principle of our government, it cannot be entrusted to people that are dishonest, that are beyond investigation, that have no supervision whatsoever as to what they do, how they benefit from the information that they receive in cases that may be proprietary, that may involve commercial secrets, and they have all that knowledge, they have all that money, they have all the connections to the banks, to the NSA, to the infrastructure of computer network and expertise of the NSA. Why would they not put it together and say this is going to be used for business? And you know what the business is? That the Chief Justice of the Supreme Court, Justice Roberts, and the late Chief Justice of the Supreme Court, both of them had said that the most important single issue in the federal judiciary is judicial salaries. It is not access to the courts. It is not the way justice is administered to the indigent. It is not the length of time. It is judicial salaries. So why would they not have said, we are going to resort now to self-help? If Congress doesn't increase our salaries the way we think Congress should have done it for so many years, so that now we are earning perhaps even more when adjusted for time than we were 20 years ago, why would they not say we're going to simply use our power, our immunity, to get money in other ways? And then the Department of Justice and Congress and the President would say, well, we're going to look the other way because we are not going to attract the retaliatory wrath of judges. And if they want to make money that way, well, live and let live. And that is why it is so important for your audience and for you to think, okay, what are we going to do now? Well, what I suggest is that through you, they contact a journalist, and then you can put together a group of journalists either at a press conference or at a private meeting, and then we can make a presentation, and they would have an interest. I was mentioning before, what would be the interest of the journalists? Well, first, to be this generation's Bob Woodward and Carl Bernstein, because they, since they were instrumental in bringing down the president of the United States, who resigned, President Nixon.
Right.
They could do the same thing. They would want to have their name go into history.
Right. But could I go in here and without bringing down your point at all, because I totally support your work, and I've met Carl Bernstein, and Bob Woodward was in my Yale class, and I know all about him. They were actually fronts for the CIA, for the FBI, and it was Deep Throat that was driving them and feeding them, and there was a war between factions of the FBI and CIA who wanted Nixon out. So there was a lot of subterranean things going here. I think here you are coming forth, this is my analysis, as a classic public whistleblower, and I totally support you in that role. So we in our role, and our audience and our kind, have recognized now that the mainstream media and the mainstream media journalists serve the corporate interests that work hand in hand with the judges, because anyone who works for the mainstream media journalists, they don't print the truth. They work for the mainstream. They continue all of the myths. So they're the ones who will not really get down to the truth about Justice Sotomayor, who keep all of these institutions in power and really don't go for the jugular. So I am going to carry forward. It may not be the journalists that you think in there, because these is a gathering of the alternative journalists. We are outside of the mainstream, and that's the only caveat that I would like to make here, because I follow Politico, I follow the New York Times, I follow all of that analysis, and if you watch them, they just talk about, treat the Supreme Court and all the other governmental institutions without any sort of the commentary that you have made, and so that's the only caveat that I have. Now, having said that, those who are in our audience who want to contact you directly and want to join in your work, how can they do so?
Send me an email.
Okay.
My email is in my file. So the only thing that they have to do is download my file.
Okay.
And they will see there my email. And I encourage them to read, because knowledge is power.
Right.
And in order to be involved in this effort to take on the federal judges, the mighty federal judges, and expose them, you have to know what you are doing. You cannot say, well, I didn't like that opinion because I just don't like it. No, it is not good enough. You have to know the facts, the law, how people work together. And I would like to respectfully disagree as to the media. The media is the one that has brought out the debacle of the Obamacare rollout. Mercilessly.
Oh, I see what you're saying.
IRS, they have exposed the IRS cover-up. This idea that the emails of the person in charge, Louis something, she took the fifth.
Lerner.
What's it?
Yeah, Lois Lerner, was that it?
Yeah, exactly, exactly.
Yeah.
Yeah, that's it. Yeah, that her emails disappear. All that. It is the media that has brought that. The media that
Yeah.
is. So the same thing with the Benghazi. The same thing with the Fast and Furious. The gun running a program of the Department of Justice, drug, firearms, and weapons running.
No, right. We will. We have lists into. I mean, insider lists into the mainstream media of the United States. Inside there, we're going to distribute this interview and your information into all of that, and we'll see what the resultant is. But we also have to create the legs for it, and that is an informed and aroused public, because that's what drives this. And I think that is very, so this is not that your and my points are opposed, but they operate together, both the media and an aroused public.
Exactly.
Because the public is the legs that keeps us going.
Without the public, there is nothing. That's
Yeah.
why I say there is no point in filing suits in federal court or the state courts because you are going to be in front of
Right.
the people that have the most interest in dismissing your complaint.
Yeah.
So there is no point in lawsuits. It has to be through the media, and the
Yeah.
media is composed of, here in this country, of hundreds of thousands of journalists.
Journalists, yeah.
Same interest.
We are going to get this interview and your material in a very open way in front of journalists, radio stations, TV stations over the next couple of weeks. We'll be doing it. And we'll do as much follow-up as we can. We'll also be getting it in front of the audience of our viewers, and to get this conversation going, because I think that in my judgment and in the judgment of any awake person, I think that comes across the effort that you've done, it's extraordinary. And I just want to acknowledge that, and to acknowledge the work that you are doing, because it really goes back to the founding fathers of the United States, and curing the judiciary and righting the structural wrongdoing there is key to the survival of justice and the well-being of the United States. So I just want to give you that compliment.
Thank you. I appreciate that. And I hope that your audience and you have the opportunity to talk to journalists and tell them the material and moral rewards that are available if they pursue this. They could be known as the journalists that brought down a justice, or even the Supreme Court, because if the Supreme Court knew what was going on, let alone that they involved themselves in concealing assets, if they simply turned their eyes away, they are also involved in the appearance of impropriety. They cover up. They became what? Accessories after the fact.
Yes.
But they become also accessories before the next act of criminal conduct, which means that first you know that something is wrong and you don't do anything, you cover up, you become accessory after the fact. But because you have given the assurance to that person that you're not going to say anything, you have become an accessory before the next act of criminal conduct or wrongdoing of that person, because of the assurance that you have given that person that you won't tell on him or her. And so there is the reward of being studied as Bob Woodward and Carl Bernstein are in every journalism school.
Yes.
The reward of being portrayed as they were in a movie, like they were in All the President's Men, of writing a bestseller, as they did in also All the President's Men, of being promoted to a more prestigious media outlet. Everybody would want to work at the Washington Post or the New York Times because they pay the most and they are the most prestigious. Or they would want to work with the national networks, which tells you that not everybody has the same interest, not journalists, because the journalist that takes phone calls from people for his talk show is not the same journalist, doesn't have the same interest as the anchor of the 6:30 news of the national networks.
Yeah. So you're asking for investigative journalists to take this issue on, and that's a fair request because of the importance. And you're bringing to public light facts and serious issues that have never been brought in a systematic way to public light in the life of this nation in as systematic a way as you can. And so now that you have put this nation on notice, that has to be taken up. And I myself am going to carry this forward. I'm going to bring it to the attention not only of journalists but all the presidential candidates in the upcoming presidential election in 2016, and have them declare what their policy is.
Exactly, but that process begins now, because I'm here in the U.S. We have the midterm election that will occur at the beginning on the first Tuesday of November. The following Wednesday, the primaries are for the presidential election begins, because that was the experience that we had in the last two elections, that the presidential election campaign begins the day after the primary.
Sure.
And then you have the primaries lasting for about a year and a half, and then you have the presidential election. So what you said is very important. It is that we have to try to get the people outraged. It is the people that is going to put pressure on politicians to take a stand on the issue. But also, it is the people that are going to give journalists a market incentive. When journalists know that if they investigate this matter, people are going to watch their newscast, they are going to read their articles, they are going to give them national recognition, as an example happened with Woodward and Bernstein. And that they publish a book. They are interviewed on TV. Do you know how much it costs to have the same? That is a type of publicity that can be paid for.
I agree. Now, we've come to the end of this particular segment. Do you have any final thoughts that you would like to leave our viewers with?
Yes, it is the importance of the issue of honesty in the judiciary for every person, even those that do not have any case in court, because of the enormous power that judges wield in making decisions that affect our property, our liberty, our lives, everyday life, and our rights. And we, people that live in a system governed by the rule of law, should take heart to have honesty in the judiciary, to have honest judiciaries and honest people that are supervised by the people. That's why I am trying to promote this idea that we are entitled, we the people. Those are the first three words of the Constitution of the United States, we the people. And then it follows, that is in the preamble of the Constitution. And for Americans, that means a lot. Those three words mean that we are the source of all legitimate political power, the people in our system, not the king, not a president that bought his way to power. We, the people, that we are the ones that should engage in reverse surveillance. Instead of the surveillance practiced by the NSA, by gathering data in bulk, we, the people, are supposed to tell our representatives we want honest judges. We want a judiciary that works transparently. Instead of having all their adjudicative meetings secret, all their disciplinary meetings secret, all their administrative meetings are secret, and all the decisional meetings are secret. Everything is secret in the branch that is supposed to administer justice. And we say that justice should not only be done, but it should be seen to be done. That is the reason why public cases are decided in public, because we want to see that the law, the rule of law, is applied equally in public. We should take then this opportunity in the next three campaigns that last from here till November of 2016 to encourage journalists to investigate this case. These are two cases, the Obama and Sotomayor case and the Federal Judiciary and NSA case, as Trojan horses. They are going to tell us not only the wrongdoing that goes on in the Federal Judiciary, but in the government. And once we know that, then we have to tell our representatives or those that are running in these elections, we want you to take a stand on this matter, because we have the power to elect you or to remove you. Why? By withholding donations, by withholding volunteered work, by withholding word of mouth support, by the opinion that we express on survey. So this is not a ludicrous idea that we can become the masters of our public servants. We have the power in practice. If we do not donate to candidates, they don't have the money to run their campaigns. If we don't spread the word, if we don't give volunteer work to these candidates, they cannot run their campaigns. So we have the power, and we already proved it. In the case of Virginia, just last month, they voted out the majority leader of the Republicans in a primary, Eric Cantor, who had been in power or in politics for some 20 years. And they voted him out. And that has scared every politician in this country, that the people have the power to remove even the people at the very top of their political powers. So what I'm telling your audience and you is that yes, we have the power if we interest ourselves in what is going on in the judiciary, in the connivance of the judiciary with the executive and Congress. We have the power to develop a civic movement that demands a new we the people government relation.
Very good.
And
Very
this is not something unrealistic. We have president, and the president is the Tea Party. It has nothing to do with what the Tea Party stands for. It has to do with the fact that it is precedent for the fact that some 10 or 12 years ago, nobody knew what the Tea Party was. And from nothing, it became to dominate in this country national power, national politics. The Tea Power has the power to shut down the federal government some months ago. The Tea Power has the Tea Party has the power to cause the 9 Republican candidates on the stage to say that they would not agree to higher taxes at the rate of $1 in lower taxes, in higher taxes, if the Democrats would give them $2 in lower spending. The Tea Party had them afraid that if they would even give a little bit in higher taxes to the rich, they would be voted out. That is the type of precedent for a new movement, the People's Sunrise. The People's Sunrise means that the people has the right to monitor the public servants, to enlighten themselves with information about what they are doing. No more secrecy. We want transparency. We want what one of our chief judges said, that sunlight is the best disinfectant.
Right.
And this is what we have to do. We can develop from an outraged public at the wrongdoing of judges into a civic movement that can demand a new relationship of we the people and the government, and that would be the People's Sunrise. And that is the last thought that I would like to leave you and your audience. There is a possibility of doing something, a lot.
Well, thank you. That's a beautiful thought, and I want to thank you for your time today and your work. And we look forward to having you on again as events develop. Thank you, Dr. Richard Cordero.
Thank you, Mr. Weber. And I appreciate also the attention of your audience.
Excellent.